Welcome to Looking at Legal Stuff. Today we have 16 hearings, including 12 family law and 4 minor guardianship hearings, in a case with a couple where mom and dad have both been struggling with substance abuse issues, and mom's sister has had an emergency minor guardianship of their daughter. Now mom and dad have been getting their separate lives together, but dad went to treatment and mom did not. Dad is first given custody of their daughter after the guardianship, while mom starts with supervised visitation. As they work towards a more 50-50 parenting plan, Dad has some concerns about Mom and her alcohol use, and he's stressed out by her vendetta against her sister, who wasn't in favor of Mom getting her custody back as soon as she did, and now Mom is trying to keep her sister from babysitting the child during Dad's custody time. Will Mom be able to get the 50-50 parenting plan and primary parent designation she so desperately wants? Let's find out.
Anyone else requesting a set over?
Yes, I'm requesting a set over.
Okay, Mr. Reeves.
So I spoke to my attorney and he kind of gave me like the website and stuff, but it wasn't the actual website. I filled out the wrong information in respondence to the parenting plan. I have all my papers. I worked really hard. I tried to get them filed and they said it's not in the right form. I did get my declaration and my treatment records in, but my parenting plan schedule was not able to be submitted.
Ms. Davenport, any response? You're muted. If you could unmute yourself. There you go.
Okay. I'm just curious exactly what it is that there's not to agree on with 50-50 and no child support.
Jesus.
I think Mr. Reeves should have a chance to look at it. Here's my issue when I looked at your cases. I think we are scheduled for next Tuesday in the minor guardianship case. And these are intertwined. And I think I need to make a decision in the minor guardianship case as to whether we're ready to terminate that minor guardianship before we take the step to do the parenting plan between the two of you. So if we put this over a week, we'll see what happens on Tuesday. Then we'll be back on Wednesday and we can address a parenting plan at that time. Does that make sense?
Yeah. So if he doesn't agree, then what does that mean? We don't get our daughter back, or?
Well, you're seeing your daughter several days a week right now.
Just 2 minutes.
Kind of a third between you and Mr. Reeves and Marlena Kennedy. And the question is whether this is the time to terminate the minor guardianship. And I want to hear from Marlena Kennedy on that issue before I make a decision.
Okay.
So let's all come back on Tuesday at 10:30 on the minor guardianship docket. And I will have in mind this motion and we'll discuss things there. As to this request for a parenting plan, I'll put it over to March 1st at 9 o'clock and it will be on Zoom just like today.
Okay.
Okay, thank you.
All
Thank
right,
you so
thank you. Thank you. Ms. Winkles had asked for a 1-week set over in this case. And I don't know if you're aware, Ms. Davenport had brought a motion in my family law docket for a parenting plan. I indicated to her, I can't really do that until we decide what we're going to do with the minor guardianship action, whether that's going to be terminated or not. I put the parenting plan over to tomorrow, thinking that we would make that decision today. But if we're putting this over a week, then I'll need to kick the parenting plan over a week also. So I'm willing to hear from everybody on that issue.
Like I was stating, can you hear me okay?
Yes, I
Is
can.
it?
Thank you.
Okay.
It's good now.
I would like to have a week continuance. Unfortunately, my mother is not well right now. She started drinking again, excessively. And because of that, she's just not well right now. And I would like that to be taken into consideration given the new declaration that she proposed. And it does give me some time to gather up enough evidence and some more, because there's a couple more declarations that are coming in. So that would give me a little bit of time. And I did not receive the declaration till literally 5 p.m. The knock was on my door. So I was not given enough time to, I mean, I read it, but I have not had any time to do anything with it. So
Sorry about that. Yeah, I have no problem with setting it over.
Ms. Davenport, you sent a note saying okay. Does that mean you're okay with the continuance?
Oh, sorry. I thought that was, anyway, yes, I will agree with my attorney. I'm going to follow her lead.
Okay. And that means tomorrow you should still show up on the docket, but I'll probably put the hearing tomorrow over 1 week also.
Okay, so I don't have to call into work then. It's just going to be a carryover.
Yeah, it's just going to be a carryover.
Okay.
Do you need to miss work to be on the docket tomorrow? Well, why don't you not do that? I'll just put it over 1 week so you don't have to miss work.
Okay, thank you.
Mr. Sal?
Can I inform my client, Mr. Reeves, that he doesn't have to attend the hearing tomorrow?
Yeah, yes, you may. And I'll just take care of it. And Cassandra Davenport and Gregory Reeves. Mr. Reeves here.
Yes.
Mr. Reeves,
Maybe I misunderstood the question. I thought you asked.
the minor guardianship issue was over a week
Similar.
yesterday.
I did.
So I need to put this case over a week again.
Or 2 weeks, right?
Was it 2 weeks? Sorry. So
It was the 21st.
so the minor guardianship matter is going to be heard on
I didn't have to go to court about
March 21. And I'm going to put this case over to March 22nd.
Okay. I had a quick question before we go.
It's all I was.
Go ahead.
So I don't know what to do. My attorney's not answering back. I've been trying to serve Cassandra like over 12 times with different people, and I am not having any luck. I tried to contacting the sheriff's department, but they said that she can refuse the right to answer the door. And I tried looking out for a company, but they don't serve in this area.
If you need to serve her with something and you are not able to, why don't you make a motion to serve her by mail? Submit that to the court. One of the judicial officers can sign that, and then you can just send it to her by the mail.
I'm usually home. So is that who knocked on the door at 10 o'clock at night when I had my daughter at 10 p.m. when I was sleeping?
I don't know what time that went, but I've also had throughout the days. I have had.
I'm at work during the days.
Okay. Well,
you can have me served. Well, let's see. I should be home. If you can find out what time whoever's serving me can serve me today, I'll make sure I'm home. Like 4 o'clock. Does that work? I'll make sure I'm home at 4.
Mr. Reeves, if that doesn't work out in the next couple days, again, you can make a motion to serve by mail. That might make it easier.
Okay, I'll try for 4 o'clock to have somebody serve her. So
okay.
Yeah. Sorry about that. I didn't know that. That's a lot of times to be trying to be served.
All right. So I'll see everybody back at the minor guardianship docket on the 21st, and then we'll be back here on the 22nd.
I do.
Okay. Sounds
All
good.
right. Thank you both.
Bye.
We're here in the minor guardianship docket. I'm Commissioner Dave Nelson. I just got a note that the guardianship of Adeline Reeves, we're going to put over 1 week. Is that correct, Ms. Winkles?
That is correct, Your Honor.
Okay, and
The one thing is we have not, Ms. Kennedy has not given her consent. Mr. South did.
Your Honor.
Ms. Kennedy?
I'm having a hard time hearing everyone. It's all breaking up, and
Yeah, same here.
Can you hear
Okay.
me right now?
I did not quite. Yes, but you're breaking up a little.
The other parties would like to put this over 1 week, but apparently they haven't checked with you. Do you have an objection to that?
No, I actually was going to see if we could possibly set it over for maybe 2 weeks, because I'm finally able to get some legal advice. It's just not until 10 days.
If we can set it over 3 weeks, then I'm unavailable in 2 weeks, but I could do.
Okay.
I'm unavailable on the 4th also, so that would put it to April 11th.
What
Okay.
about my daughter's birthday is April 4th? Can we make a thing where I can spend time with her on her birthday? She's turning 4 on April 4th. And I'd like to see her on her birthday.
And probably both parents would, I would assume. Not to speak for dad as well, but
Tuesday, he
something.
gets visitation with her. I could take the day off of work and spend some hours with her. And then
Well, without Greg being here, that's his visitation day. And it's Cassandra has had every holiday, like her visitation is on every holiday. And I mean, I'm sure Greg wanted to see her on the holidays that
so I could see
was
her while he's
with
out
Miss
work.
Davenport.
All right, we're not gonna have this argument here.
Okay.
I will make a decision on that. I understand the issues. I'm gonna put this over to April 11th at 10:30. There's already an order. Just a minute.
What? Oh, if you want.
I already signed an order extending the immediate emergency, actually the emergency minor guardianship until the full guardianship hearing is heard. And I don't know that that's been scheduled, but that's going to remain in effect. I have indicated a visitation schedule for both parents. And so Ms. Davenport is asking that she be able to see Adeline on her birthday, which is April 4th. Is Adeline in any kind of daycare or Head Start or anything on that date?
Yeah, she's in Head Start.
And how long does that go to?
She's in Head Start from Tuesday through Friday from 8 a.m. to 11:30.
Okay. All right. I'd like Ms. Davenport to have time with Adeline from 1 to 4 p.m. on that date.
What date was that, Your
On
Honor?
April 4th. And if that's Mr. Reeves' time to be with Adeline, actually, I thought his time started on Thursday, but.
He also gets her Tuesdays from 3 p.m. to 8 p.m.
All right, so his time is going to be delayed then till about 4:30 on that day. Okay. You can let him know that. So Ms. Davenport, you can plan the birthday celebration between 1 and 4 on April 4th. Okay. All right. Anything else on this case?
No, Your Honor.
Ms. Smith, you'll be able to be back on April 11th.
Yes, Your Honor.
Good morning, everyone. We're here on the Pro Se Family Law docket for March 22nd. I'm Commissioner Dave Nelson. Let me call a couple matters that I think are going to be shorter. Ms. Davenport, I see you here. And based on what we did on the minor guardianship matter, which we put over to April 18th, I think this matter needs to be put over to April 19th at 9 o'clock. Will that work? You're muted right now, Ms. Davenport.
Okay, I'm sorry. My phone, I'm on my way to work, and I thought we put it over for April 11th.
I think it was ultimately 18th because of everybody's schedule.
I'm here to help you answer any questions. Just put it on mute.
Okay, yeah, if we need to hold it over, that's okay. Are we allowed to, do I need to respond to his response or for this matter?
You're able to file any documents you'd like. So if you want to file a response, that's fine. Okay. All right. I'll see you back here then on April 19th. All right. Let's go to guardianship of Adeline Reeves. And at this point, there's been a motion to continue by Ms. Kennedy. I think everybody got her email on that. And so let's take that up. I think today is the day scheduled for a hearing as to whether this guardianship should be terminated. And so Ms. Kennedy, I'll let you lead off on that.
Well, I am not able to get into seek or talk with legal representation until Wednesday, tomorrow. I was not able to get in sooner. And so that is why I wanted to have a continuance, just so I'm able to speak with her. And I've been extremely busy at work. We've been down a couple housekeepers the last couple weeks, actually. And they also started training me for second head housekeeper. So I've had a couple extra hours. So I haven't really had time to put together my final declaration either. So, or submit that. I mean, I have it started. I just haven't been able to get it finished. And I wanted to go over my final declaration with the legal representation. So if there's any way we could possibly send it over, maybe a week or two, that would be great.
All right, Ms. Winkles.
Yes, Your Honor. My client would like to go forward today. She actually asked people to appear on the record for live testimony. Additionally, we prepared a trial notebook with exhibits and a trial brief. We've continued this a number of times. If Your Honor will remember, the parenting plan action can't go forward unless this has been decided. The father and the mother are ready to essentially take this to the next level and deal with it in the family law court. Now, Mr. South will be able to explain the father's position more, and he might be okay with the continuance. But my client prepared. Now she has to call back everybody, and hopefully they'll attend the next time. But it does make it very difficult, and it costs the county money every time this happens.
Yeah, I also recently went under emergency surgery, and that really put a loophole in things. And to be honest, I spaced that today was the hearing. So I have not been able to get really my ducks in, like my last few ducks in a row. And I have not been able to seek legal representation this whole time due to funds. But with a current side job that I'm doing, I now have access to free and deeply discounted legal services. And I would really like the opportunity to do that because I could not afford to get an attorney.
Okay, let me hear from Mr. South, okay?
Your Honor, excuse me, Your Honor. We don't really have a position. My client, unfortunately, isn't in a position that he could be here today unless he was able to show up. And so we would be in favor of the continuance. Also, I received Ms. Winkle's trial brief. I just saw it this morning. I really haven't had a chance to look at it yet. And it's probably 200 pages.
And I just received that last night.
I understand it was delivered to the court at 8:30 this morning, and I haven't had a chance to look at it.
Yeah, and essentially it's just, I'm going to have to authenticate all the exhibits anyway. So rather than do it like we used to do in court where I just show up and I hand people papers, I elected to give it to everybody in a clipped format, but I have to authenticate all the evidence anyway.
Ms. Smith, are you on this case?
I am, Your Honor. I'm the appointed GAL.
Do you have a position on the continuance?
I will defer to the court in regards to the continuance. I don't have a position either way. Ms. Winkles, I don't know that I've received the trial brief though.
And you won't, as the GAL, you're not a party to the case, so you only get what you're being questioned on as a witness, which would be your report. I can send it to you. It's just, I don't mind. I just didn't because I was just going to question you about your report itself.
No problem. I just wanted to make sure that I didn't get lost or that I didn't get lost on my end.
Would you like it? Because we can send it to you, but we probably have to deliver it to you. And I don't believe you're in the area.
I am in the area. It's fine.
Oh, you are?
Yeah. No worries.
Okay, we'll have it delivered. That not a problem at all.
Mr. South, are you able to make it next week?
Should be able to.
All right.
The 18th.
There have been a number of continuances in this case, but I don't remember that Ms. Kennedy has asked for one of them. I know the other parties have asked for continuances. It looks like Ms. Winkle's material has just been delivered to me. I think based on what appears to be late filing, based on the indication by Ms. Kennedy that she's about to meet with counsel, and I'd like her to have that opportunity. Based on the fact that Mr. South hasn't been able to look through the materials yet either, I think there is good cause to continue. I'm going to continue this only 1 week.
Your Honor, I have a request. I have 8 hearings next Tuesday. Can we do a special set for a different day?
Special set is going to be 6 weeks from now. And I have to have you go to the universal trial setting. They'd have to find a spot for me. You don't want to do that.
No, I don't want to do that. So I will figure out something.
Either that or we go out 2 weeks.
2 weeks is judicial conference.
Oh, that's right. It won't. So that would be 3 weeks out. I don't want to go out that far. I really want to do this next week, and then
I'll make it work.
I have scheduled on the 19th the hearing for the parenting plan. So depending on what I do in this case, then that would allow me to address that. So let's put it out to April 18th then at 10:30.
And Your Honor, in the interest of saving time, instead of having all these people give live testimony, can we do their testimony on pleadings and have a date certain where those pleadings are put before the court? As in all the third parties, that the parties in this case can testify, but is there a way to allow third parties to testify via declaration and just say everybody's declaration from a third party is due on such date? I'm just trying to keep it down from 5 hours.
I know. I am not inclined to do that in terms of ordering it, because I think part of what I'm evaluating is the credibility of the witnesses. And if I just have declarations, I really have nothing to help me with the credibility.
Absolutely.
So I am, in this case, I think credibility is important for me to consider. So I'm not inclined to have the witnesses or order the witnesses, just do it by declaration. If any of them want to and cannot appear, want to put their testimony before me, that way they can do that. But I'm not going to order that.
Okay, thank you.
Okay, we have on the 18th, we have 6 matters. I'm not sure how long they're going to go. I'll take this case last, and I'll note to the judicial officers here, the judicial administration, that it may go after the noon hour. So if we get up to the noon hour, we'll take a break and then we'll continue after that if we need to do that. This case, my estimation is it will take several hours to go through the evidence and the witnesses.
And Your Honor, I may have to pop off shortly at the 1 o'clock hour for my 3 motions that I have on the family law 1 p.m. docket.
Well, then we could maybe start up again at 1:30 if we needed to.
That'd be perfect. Thank you.
So we'll address that next week then, okay? All right, so we'll continue Adeline Reeves to next week, April 18th at 10:30. We'll see everybody back then.
Thank you, Your Honor.
Thank you, Your Honor.
Good morning. We're here on the self-represented family law docket A. It is April 19th, and I'm Commissioner Dave Nelson. Let me take care of a couple things that are going to be shorter. So Cassandra Davenport. You want to unmute yourself a moment?
Yeah, okay, got it.
So, you know, we're having the hearing on the minor guardianship tomorrow.
Yeah. At 10:30, right?
Right. So, and I want to go through that hearing before I determine whether we're going to jump into a planning plan. And I would put this over to next week, except we're not having this docket next week. So I need to put it to May 3rd at 9 o'clock. Okay.
Okay, hang on, I gotta write that down. Sorry, I'm at work. May 3rd, 9 a.m. All right, awesome, thank you.
All right, thank you. All right, Ms. Kennedy, are you prepared to go forward?
I just have my phone now. I'm just using my phone because I'm not going to connect to Wi-Fi.
Okay. All right, Ms. Winkles has suggested that you begin the case, and so I'm going to place you under oath, and the issue that we're addressing is whether the emergency minor guardianship should remain in effect or whether it should be terminated. You can put your hand down.
Okay, I did.
You bet. And so let the court know in your own words why you feel the minor guardianship should either continue or be modified or whatever you would like.
I actually, my final declaration that I submitted, I agreed with the guardian ad litem's report. I completely agree with it. Greg has shown tremendous improvements. Given the fact that he graduated treatment, he only told me and his mom and his family that he was graduating and wanted to remain in treatment. And that was found out from the guardian ad litem by doing her investigation. So I agree with the guardian ad litem's report. If I do think a transition would be, well, I mean, she already, yeah, honestly, I agree with the guardian ad litem's report. I didn't do this to take custody or, you know, have full custody for until she was 18. I did this just to kind of, in a sense, I get them to kind of shape up, I guess. I don't know how else to put it, because I was worried for my niece, what she was witnessing and going through. And so I just did it just to hopefully give that push for them to get the help that they needed so my niece could have both her parents. And so, I mean, the guardian ad litem, I trusted her throughout this whole case, and she feels that Adeline, it's time. And I believe it's time too. Again, Greg has shown tremendous growth. He has a very strong, good support system. I'm going to keep my schedule as the way it is now. So that way, if he needs me for Adeline, I can still be there without having to make any big changes or anything. So, I mean, now if you're not in agreement with her report, then I am in agreement with her staying with me, of course. But honestly,
I agree. I agree that it's time for her to go with her father. I do not think Cassandra has shown enough growth, given the fact that in the exhibit of my declaration, she had my mom message Greg just on Easter, which one goes against the protection order, which she's had an issue with throughout this whole case, asking if he wanted time with Adeline on Easter, which also goes against what you have put in place for for visitation. And that is also another issue that she has had. There has been a complaint from her regarding me, what I'm doing. Oh, well, Greg gets this and Greg gets that. And she doesn't understand the fact that they're two different people. And Greg has shown more growth. Cassandra has not followed even the littlest of rules throughout this case. Again, she has stayed the night at my mom's house with Adeline. That goes against what is set for visitation. It's little stuff like that, I think. And change is evident. It doesn't need to be told. And having my mother every chance she can tell me, Cassandra's changing, she's changing, you just need to see it. And then telling Greg the same thing, that's not growth. That's, again, it's evident, it's not told. And so I agree with the guardian ad litem.
All right, so the guardian ad litem says that primary custody should be with Mr. Reeves. And the guardian ad litem indicates visitations with the mother should still be supervised, and then has a number of counseling and other recommendations. So you agree with all that?
I do, yes.
Okay.
And I just want what is best for my niece. And I believe that right now, her going with her father is what is best for her, physically, mentally, emotionally. I just think it's what's best.
All right, thank you. Ms. Winkles and Mr. South would have an opportunity to ask you questions.
Before I do that, Your Honor, I would move then to dismiss the minor guardianship, the emergency. It sounds like Ms. Kennedy is in agreement. The only question would be the transition until the family law court matter's heard in 2 weeks. So, Your Honor, I'm making a motion to dismiss the emergency minor guardianship 2-week transition till the family law court action, roughly on the same parenting that's in place right now, with both of them having the same visits that they have now. Dad can have the additional, and because it's 2 weeks, and that Miss Kennedy had the additional 2 days, and then this matter can be heard in 2 weeks. It sounds like Miss Kennedy is in agreement that Dad, at least one of the parents, is fit, or at least one of the parents has the basic parenting function, so there's no need to go on with the trial today.
If I do that, I'm going to leave supervised visits in place with the mother until we get to the parenting.
She doesn't have supervised at this point in time right now.
She's always had supervised.
Thought she had supervised except for about 1 hour a day.
Oh, yeah, and that's fine. We can leave. I think my client, if she can give a thumbs up, to leave that for 2 weeks until such time as the matter is heard between her and Mr. Reeves in the family law action.
All right, Mr. Sal.
Yes, it almost sounds like the petitioner is withdrawing her petition, but it might be better to, in order for the court to maintain some jurisdiction over this for the supervised visits. I'm not sure what is the best way to do that. I think in the last case, they had a tentative order.
And Your Honor, if I might, that's not needed if there's a transition. The transition still, the court still has jurisdiction over that transition period of 2 weeks.
Okay.
Until it's heard.
Okay, well, that would work. If I could inquire to the court, yesterday, the family law case was.
I put it over to May 3rd.
May 3rd, okay, thank you.
Yeah. Because I needed to know what was going to happen in this case.
Okay, well, then our position is that the court follow the GL's recommendation, her first option, that the child go to my client, Mr. Reeves. And that the visitation, I guess, stay the same with mother.
And Your Honor, could you put me in a breakout room with my client just for a second?
Sure.
And my client agrees, in the interest of moving this to family court, to agree to supervised visitation on her same schedule for the next 2 weeks. And I'll go ahead and write those orders and circulate them today.
No objection here.
Let me hear from a couple other people, and then I just want to make sure everybody is heard in this case. So Ms. Smith, anything you would like to add?
No, Your Honor.
Okay. Anybody else who wishes to be heard in this matter? All right. So under RCW 11-130-225, the appointment of an emergency guardian is allowed where the appointment is likely to prevent substantial harm to the minor's health, safety, or welfare, and no other person appears to have the authority, ability, and the willingness to act to prevent substantial harm to the minor's health, safety, or welfare. Earlier in this case, it was necessary to appoint Ms. Kennedy because the parents really were not in a position to care for Adeline at that time. And I think Ms. Kennedy should know that she has the court's appreciation for stepping in at that moment and being involved. And it is difficult after that to let go, but she's willing to do that. At this time, the court is convinced that Mr. Reeves is now able to care for Adeline in a way that does not impact her health, safety, or welfare. And so I'll do it this way. I will terminate this guardianship as of May 3rd. Let's say May 3rd at noon. I'm going to hear the family law matter on May 3rd. And at that time, I'll determine what the parenting plan will be for between Mr. Reeves and Ms. Davenport. As far as I'm concerned, Mr. Reeves at this point can have Adeline full-time if he wishes, with the same visitation schedule to Ms. Davenport that's been in effect. So there'll be several days during the week where Ms. Davenport will see her. Or if the parties wish, we can continue the same schedule we've had with the minor guardianship until we get to the parenting plan. Do either of you have a preference on that? Let me hear from Mr. Reeves first.
I'd prefer to just stick to what we've been doing, and I will fill in those days that Marlena had her. I will pick her up after work, and I'll have a range while I'm at work.
All right, so you'll go ahead and take Adeline the days that Marlena had her. Is that right?
Yes.
And then the schedule that I had adopted for Ms. Davenport will just keep for the next 2 weeks. And I want both parties to know that schedule is going to change on May 5th. It will necessarily change when I do revise the parenting plan.
Okay, so I just want to get this all straight. So May 3rd at noon is when we have the court.
No,
right?
it's May 3rd at, I believe, 9 o'clock. I'm just extending the minor guardianship to that time. It will terminate when I make a parenting plan.
Okay, that sounds good.
I didn't want this court to lose jurisdiction before we got to the parenting plan. So that's why I'm doing it that way. Okay.
Okay.
Ms. Winkles, does that work?
That works, Your Honor, for my client as well.
Okay. All right. For everyone who is here as a witness, I really appreciate you being willing to be involved in this case and participating. It's what helps the system work. So I appreciate you being here. I also support and encourage the kind of resolution that we had today. Ms. Winkles?
Yes, Your Honor. I'll get those orders over to everybody in the next couple hours.
Okay, I'll be here. We do have a question. Ms. Winkles, you've turned in a number of exhibits in this case. Do you want those back or do you want those destroyed?
I'd like those back so that I can give to my client for the parenting plan action.
Okay.
We'll have Roger come pick them up.
And if you want to do that, I have your binder in this case. May I utilize that in the parenting plan action?
Absolutely, Your Honor. Thank you.
Okay. All right. Anything else, Mr. South?
Nothing, Your Honor.
All right. Mr. Reeves?
Nope. Nope. I think I got everything.
All right. Ms. Davenport?
Is there, I can't get a little more time in the next 2 weeks, huh?
No, I'm going to leave it where it's at.
Okay. Thank you.
Ms. Winkles?
Nothing further, Your Honor.
Ms. Smith?
Nothing, Your Honor.
Okay. Thank you. Cassandra Davenport and Gregory Reeves.
Yes, I'm here.
All right, thank you. All right, I dismissed the minor guardianship, so we're here to at least determine an initial parenting plan between Ms. Davenport and Mr. Reeves. And Mr. Reeves, let me let you go first on what you think would be appropriate, and then I'll hear from Ms. Davenport.
So I'm not exactly sure what to do for the parenting plan. I mean, I've expressed my concerns. I'm just mainly concerned about, I haven't talked to her or really know exactly what progress has happened and stuff. I'm just concerned with her emotional well-being and how she handles things. Just concerned for my daughter in that sense that, if she's throwing a fit or something and Cassandra gets too stressed out or something, the way she reacts. So, I mean, I just kind of put in what, as much time with me as possible, but I just kind of was going to leave it up to the courts to decide. I had suggested supervised visits and stuff. I just don't exactly know where she's at, just, with the protection order and stuff. And I don't feel completely comfortable. And, I would like to say, even if it's not as much time with her right now, that, we can down the road, my goal is for us to go 50-50, but just with me right now, I'm not necessarily comfortable, just given all the past and, just worried that, she might not be able to handle herself and get too overwhelmed.
Okay, thank you. Ms. Davenport?
Yes, I understand your concerns. I have reacted ways with you. We both have to each other. But when it comes to my daughter, I would never hurt her. And you, of all people, you know that. And I believe that she's safe with you and me. And my concerns is with you is the stability. I'm not trying to attack you or anything, but this is about our daughter. I just moved out. Adeline had just gone through a big change for her of losing her parents. And then you move in a known drug user. And within a month after that, that's not like appropriate. I don't feel like it is for a child going through all the change. I feel like you didn't put her emotions first. And then you eventually had Alexia leave. You kicked her out. She had to leave, March 15th or 16th. And now you're currently with another girlfriend. And it's like, what you do with your life is none of my business, okay? I'm also seeing a man, and I have been for a while, but our daughter has not met him because that takes a lot of time. And I feel like it's just, she's got enough change going on right now. He's a very decent man, has never had any addiction issues. He believes in God. He's really a good man. And eventually I would like you to meet him before I introduce him to our daughter, because I respect you as her dad. And she deserves parents who respect each other and put her first. And I really want to work with you. I'm sorry, I'm so emotional. Like he said, emotional. But I want to work with you, Greg. I really do. I want to address your concerns and just work together. And I've told you that before all of this happened. And I was serious about that. And I understand child support is really hard. But I do believe that if you're struggling with buying a pair of shoes, then I can take over and vice versa. I believe that we can work together and we can help each other out for our daughter. And I need to make sure that you can provide her stability. Also, your work schedule. You know, Marlena is not a safe environment for her. There's statements in here, even from your ex-wife, about it. And that they smoke pot in front of our daughter. Our daughter is now saying PUSSYFARTS. She's cussing. She's just got very inappropriate behavior. And she's not getting that from me. And I don't think she's getting that behavior from you either. And I just don't believe that Marlena is a safe place. However, and if I had her during the week, I would be able to take her to school, and then she could go to daycare after school, and she would have that structure and stability. And then you could see her right when you get off work, you know, up until bedtime, or we could figure this out. I do not want to keep her from you because she needs you just as much as she needs me, and she is safe with me. Also, Holly and Beverly are on Zoom. If it's okay, if they could quickly say something, the people that are around me on a daily basis. That way it gives you a little more reassurance. So I don't know. I've changed a lot. I've had to face myself and the way that I reacted to people, and you, and I am sorry for the way I've treated you. I had a lot of insecurities. I couldn't trust you. And I'm sorry for that, but it's just, I can't take any of that back. And you matter just as much as I do. I don't really know what else to say.
Okay, let me hear from Mr. Reeves if he has any response. You're muted right now, sir.
Yeah, I admit the moving in before was a rash movement, and I did try for a while to get her out, and then we broke up super early on, and then she said she would help out with rent, but that really never happened. I still think she's a good person, but yeah, it was not a good fit. I am seeing a different girl, but I did wait a while for her to even meet my kids. She even was about that with her kids. I looked into her. She's got her life together. She has her own place. She's worked at her job almost 19 years. She just seems like a really good person. So I really, thought long and hard on this one. And as far as Marlena, I do trust Marlena, but I have arranged other care for while I'm at work. My cousins said that they would take her Monday and Tuesday. Marlena asked about Wednesdays, and I did not want to tear her from her auntie. She has,
right. Yep.
been with her auntie for so long. I didn't want to tear that. And then my mom has her Thursdays and Fridays until I get off work. So I, have arranged all that. And
she has, sorry.
So yeah, she stayed the night with Ian and Nikki last night. And, I've been keeping up on, trying to, the doctor's appointment. And I did get some numbers for like, the ultrasound stuff because he keeps getting those bladder infections. Yeah. I've been trying to keep up with all that stuff.
That's because of improper care and diet. Remember, we had her on a certain diet.
Ms. Davenport.
Sorry.
Yeah, I just don't know really where I'm at and where my trust is and stuff like that. I just, there's been a lot that's gone on between me and you. And I'm just trying to do whatever is right for Adeline. I mean, like I said, I still do concern that your emotions might get the best of you. I just kind of, since I have not been in your life and we've had this protection order, I kind of am leaving it for the judge and his observations and the guardian ad litem and whatever he decides, and that we will work from there. on, how much time and what goes on. And then, like I said, eventually my goal is definitely 50-50. So I just am leaving it in the judge's hands on what he decides.
Okay, so back to the stability thing though, she's having to stay different places all throughout the week when she could be with me and have stability.
Ms. Davenport, I think I'm going to address that.
Okay.
All right. So both parties know I've seen you multiple times through the minor guardianship matter, and we've been on this docket a couple times. Both of you have grown a lot. Both of you have really turned your lives around since I first met both of you, and so I want to commend you on all of that. And I'm very happy actually that we're here doing a parenting plan. The first thing I'm going to do is I'm going to remove the supervision requirements for the visits with Ms. Davenport. Okay. I understand that there's a feeling there may be a risk to that, but I think this is the time to take that risk, and we'll be checking in from time to time to make sure things are going okay. Okay. My recollection is under the minor guardianship, Ms. Davenport, you had Adeline from, was it Thursday to Sunday?
No, I get her Saturday at 6 p.m. till Monday at 6 p.m.
Okay. Okay. So my thinking today is I was going to leave that in place and remove the supervision requirement. That I know that doesn't give you as much time as you want with Adeline. I want that to go on for a month, and then I want to look at expanding the time after that. But I want to make sure the time without supervision goes well. I'm going to have Mr. Reeves be the primary custodial parent. Just so you know, I think it is, it does make sense for Ms. Kennedy to see Adeline at least once a week. So I think that's good. So the first visitation I'm going to order will be from Saturday until Monday. I guess Saturday at 6 till Monday at 6. I wonder, well, no, I want to leave it at that. And then I want to get back together on June 7th. And so you both know if everything is going fine, I'm going to expand that. I don't want Mr. Reeves to lose every weekend, but I want Ms. Davenport to certainly get more time with Adeline after that. But I want to make sure we can take this step where there's no supervision and that goes well.
Okay, thank you, Your Honor. So transition time is hard for our daughter. I believe that it would be easier if we could do pick up and drop off together. If it works for Greg, that we meet at my mom's, that way there's someone here that's, can witness, he could bring someone to. Anyway, if we could directly hand our daughter off to each other and in this time, and if there's any problems with that, which I don't believe there will be, if
Mr.
we could do that.
What's you're thinking about that?
I'm a little hesitant. I mean, I guess if we, kept it short, I just don't want to get into any arguments and stuff. I have that protection order. It could work out. I'm just a little, worried that it,
And again, we're taking some risks here. Okay. I'm going to relax the protection order to allow you to do a direct handoff. I would like it to be, if it's convenient, at Ms. Davenport's mother's house. If there's to be no discussion about anything other than, this is when she had her nap, or this is what's going on with her. If it goes beyond that, if there's any concern, then we're gonna snap back to what's in the protection order right now.
And is there any possible way that, like, if sometimes, as long as someone's present or something, that it's not at her mom's, just because, I mean, her mom's house is all the way across town from where I live. I mean, sometimes, I mean, I'm willing to do that a lot of times, but sometimes it'd be nice if, I wouldn't even care if her mom was there if we like met in a different area once in a while. I mean, sometimes it works out fine, but you know, does it have to specifically be at her mom's, or just to have somebody present when we?
I would like somebody present. I guess that makes sense. That
What if
if
we,
there-
either
Go
you
ahead.
pick up and I drop off, if my mother and I like go to your place to pick her up on Saturday, and Monday you pick her up from my mom's, would that be easier?
Probably Saturday would be easiest for for me to drop off at your mom's. Monday would probably be easiest just to pick up for me, just because Saturday I don't got anything going on. It's a weekend. Monday it's like I just get off work and all that stuff and have to make dinner and stuff like that. So
Will that
yeah.
work for the Monday drop off, then to drive to Mr. Reeves' house?
Okay, yeah,
Okay.
that would work.
Okay, let's
Thank
do
you.
that. All right,
And
we'll be back here on June 7th, and we'll make some adjustments then. Okay.
What time on the 7th?
9 o'clock again.
Okay.
All right, thank you.
All right.
Next up is Davenport and Reeves, and I think Ms. Davenport is asking for a continuance. Is that correct? You're muted right now if you want to unmute yourself.
Yeah, I'm really sick right now. But other than that, without the continuance, I think with no contact order lifted at this point, I feel like for me to feel safe and Greg to feel safe, I would like another month of him and I being able to text, and his daughter call him and my daughter call me in each other's care, and see how that goes. Like, I want to keep the courts involved for right now. And also, sorry, I'm really sick right now.
All right. How far out do you want to go on the continuance?
We'll leave that up to Greg. I'm thinking maybe a month, but it's also up to Greg. So,
Mr. Reeves, any comment on putting this out a month? You're muted right now if you want to unmute yourself.
I feel good.
Mr. Reeves, I don't hear you.
Well, I want to keep the courts involved.
I'm willing to do that. Do you want to go out to by 12th?
So he said it's not working.
Oh.
Yeah.
Mr. Reeves, let's work through chat. Can you hear me? All right. Do you have any objection to putting this case out to July 12th? He said no. So, okay. So we'll just put this out to July 12th and see you both back here then.
Okay. Also, with that, are him and I allowed to talk one-on-one, like through phone? Not him and I, but for our daughter. That's all I want.
You want to be able to communicate directly with Mr. Reeves regarding
our daughter, and I have to take her to Portland on next Monday. And it's like, I don't have to, but I'm going to, like, type of thing. So I want to be able to communicate about medical issues with her, or just anything. Sometimes she asks for daddy, and, and it's like, I tell her daddy's at work. I'm sorry. We can't call him right now. And him and I agreed on that. So
Mr. Reeves, again, using the chat, do you have an objection with talking to Ms. Davenport directly regarding Adeline?
it could be through text. That way there's proof of everything.
All right, she's indicating through text. All right, so that's fine. You just wants it to be minimal.
Same here.
Can we
Same
do
here.
that?
But I really want to keep the courts involved because
All right.
I never got to say like my side of the story. So I'm a little hesitant to, sorry.
So let's do it through texting and do keep it minimal, and
Okay.
either side has a problem with what's
Okay.
texted, you can bring that to the court's attention on the 12th.
All right. Also, one more thing, Father's Day. That's my visitation day, but she needs to be with her dad. It's Father's Day. So what do you recommend for him and I to do? Like switch days?
Why don't you see if you can switch days? Normally a Father's Day would take precedent over other days. So
Absolutely.
send a text over, see if you can work that out.
Okay.
I think the sooner you and Mr. Reeves are able to work together to deal with those kind of issues, I think the better off everybody's going to be. Okay.
Okay.
All right. Thank you for being sensitive to Father's Day. I appreciate it.
Absolutely. She has a dad that fought for her. I'm not gonna, yeah, I love that. All right. Thank you.
All right. I hope you get better. We'll see you back here in a month. Thank
Yep.
you, Mr. Reeves, for working with us through the chat.
All right. Bye.
And then I think I have Cassandra Davenport present and Gregory Reeves. This is 233-000-3408. Good afternoon. Thanks for your patience. Okay. So the last thing I have is a review hearing you had on May 8, 2023. That addresses who the primary custodial parent is. Looks like there was some modifications to visitation. And then the court set this review date, presumably to see how those modifications on visitation are going. What can you folks tell me?
I think that they've been going really well, and you know, we've talked about it, and we would just kind of like to move forward to the 50-50, and I myself personally would like to just extend the time that she has from Saturday, instead of ending at Monday at 6 and Tuesday at 8. I think to make it exactly 50-50, she'd probably have to have her a little bit earlier on Saturday than 6. But I mean,
so so is your proposed parenting plan had last been filed February of this year, it looks like. Are you, sir, still sticking with your request from that proposed parenting plan, or are you wanting something different?
I'm wanting something different. Things are going a lot better than what I expected, and I think that we both could be happy with the 50-50. No child support from either one of us, and I think that we could just work this out.
And okay, that's really good to hear. On the mother's end, does that comport with kind of your hopes for this case?
Yeah, originally I wanted to do 1 week on, 1 week off, but him and I both agreed that that's just too long without seeing our daughter. She's only 4, so.
Okay. So what I see here procedurally is that we don't even have temporary orders in place, an actual temporary parenting plan. We just have some bench orders addressing kind of small pieces of this. So if you folks, what I think we should do is set a new date for you. We could do that even 2 weeks out if you think you could get something to the court by then. what I would want is your new proposed parenting plan. If it's agreed, if the two of you are working together and presenting an agreed temporary parenting plan to me, certainly makes everyone's life easy. But if there's small pieces that you want me to decide, that's fine too. I would just ask that what we'll do is we'll set a new date. You guys can tell me how much time you want, submit a new proposed parenting plan, and then we'll go ahead and enter that, hear any argument on small sticking points, and then get you guys that order.
So that works for me. If there's any way we can set this out quite a ways out, I'm kind of getting in a lot of trouble for my work, having to take this much time off. So it would actually work out a lot better for me if it could be moved out. And I don't have a problem with, if she was to have more time during the week until that court date. For work purposes, it would work better for me if it was set out a lot more than 2 weeks from now.
Yeah, and that's fine. How much time do you guys want?
Whatever works best for him.
Do you want a month, or do you need more than that?
Maybe a little bit more than that.
Okay. Let's do let's see, we're here on July, so it's July 12th. You want to do September 6th?
Yeah, I think that should work fine.
Okay, so let's set this on for September 6th at 9 a.m. What my notes will reflect is that my assumption, and if things change, that's fine too, but my assumption at that time is we'll be entering a temporary parenting plan for you all. And then we can discuss how you want this case to resolve for permanent parenting plans. Okay. The other thing is you asked for the bench order right now. It allows mother Saturdays to Mondays. What are you wanting? Are you wanting the visitation to have specific days in it pending the next hearing, or what are you asking for?
I would ask that maybe it go till Tuesday at 8. So she'd have another overnight. She'd have Saturday overnight, Sunday overnight, Monday overnight, and then at 8, we can arrange for a place to meet to pick up, and that's how I'd like to do it.
Would that work for you, ma'am?
Yeah.
Okay. And certainly what I'll say is, because we're not doing an actual temporary order or a parenting plan, I mean, if, this is allowing you those dates, if the parties find that doesn't work, this is not mandatorily the child must be with you during these days, but we are allowing that visitation. So I will issue a new bench order today, extending that Saturday at 6 to Tuesday at 8. Otherwise, all other, visitation remaining unchanged, or custody remaining unchanged. And then we'll address all of those new issues when you submit me a new parenting plan and we come back on September 6th.
Okay, thank you.
Okay, anything else you need from the court?
I just, first time I submitted a parenting plan, I had a heck of a time. I got the wrong form and stuff. I just want to make sure what's the right form, so I make sure I submit the right one and don't have confusions again.
Yes, so it is the family law form 140, and it's called parenting plan on the top.
140?
Yep.
And it's family. All right, that sounds good.
Oh, he can. Oh, so they do have blank forms for those at the Superior Court Clerk's office if you'd like to pick it up here.
Okay.
Yeah, I learned something new every day. Yes, you can grab those here apparently. All right, you both are free to log off, and we'll see you back September 6th.
We have a pretty full docket today, so I just want to ask first and foremost if there's any strikes or agreed continuances this morning.
Can you hear me?
I can.
Okay, sorry, I don't know how to turn my video on, but I was wondering if I could get a continuance. My name's Cassandra, because I just got to urgent care. I've been having problems breathing, and they told me I need to go to the emergency room.
Okay,
So,
what is your full name, please?
Cassandra Davenport.
All right. So it's 2330003408. Do we have Gregory Reeves?
Yes, I'm here.
All right, so Mr. Reeves, sounds like Miss Davenport is asking for a set over, because she's at, I'm sorry, are you at the emergency room or urgent care?
I'm in the parking lot of urgent care. I just walked out. They told me I had to go to the emergency room because of my symptoms.
All right. Mr. Reeves, are you agreeable to setting this matter over 1 week?
Yeah, I have my concerns, but yeah, it'll be hard for me to just get off work and tell them it'll be set over a week.
Do you want 2 weeks? Would that be better?
Yeah, that'd be better.
We can't do 2 weeks, but we can either do 1 or 3.
It's up to you, Greg.
I guess 3.
All right, I can set this over to Wednesday, the 27th of September at 9 a.m.
Yeah. And do I need to file the paperwork from the emergency room today? Just for proof?
I think, or provide it to Mr. Reeves.
Okay.
Okay, and we'll set your matter over 3 weeks to the 27th at 9 a.m.
All right, thank you guys.
All right, good luck.
Thank you.
Is there anyone that is in agreement simply to have their matter set over to a different week? Yes, what is your name on the Samsung? I cannot hear you, sorry.
Cassandra Davenport.
Oh, Cassandra Davenport, okay, there you are. This is a temporary parenting plan, and I think I had looked at, oh, maybe not. Did you submit proposed orders yet?
A while, quite a few months ago.
Okay. Do I have Gregory Reeves present?
Yes, I'm here.
Okay, Mr. Reeves, it sounds like, well, in all reality, you're number 17 on our docket right now. I'm calling number 15. So there's a chance we would get to your case, but if you both are in agreement to set over a couple of weeks, I can certainly grant that. What is your preference?
I'm fine with it being set over so I can get more witness statements.
Mr. Reeves, what is your preference?
I'd prefer if it didn't, but if it's going to be, I'm going to need it to be set over like at least a month, just because it's hard for me to get this time off work.
Okay, I certainly understand, and apologies for this lengthy docket. We're certainly not trying to screw up people's daily schedules. It's just kind of the way these things go. So if we continue it, would October 25th work for the parties? That would give you 4 weeks to request that time off, sir. And then, ma'am, that would give you time if you are filing additional evidence for the court to consider.
Yes, if that works for Greg, that's fine.
October 25th. Yeah, I think I could do October 25th at 9 a.m.
Yes.
Good. All right.
Okay, well, I'll get you both set over to October 25th at 9 a.m. And then I don't have proposed orders in front of me for the temporary parenting plan you're requesting. So if that's something you want me to look at, or if there's new orders since you filed this case, please get those to the court before the 25th.
Okay, so what orders would we have to actually file, like a permanent parenting plan or a new temporary one?
So my understanding is that Mr. Reeves filed a proposed parenting plan back on February 28th.
That was after my attorney and I did a temporary one for.
Well, you did a temporary one. I'm just looking at his proposed parenting plan that he filed.
Can I say something for a sec?
Sure.
I mean, the whole thing was I was ready to go 50-50. Everything was going pretty good. And then I had my concerns, and that's kind of what I wanted to talk to you about. This court was the problem, to see what to do to go forward.
Okay. So my recommendation would be, since I don't have proposed parenting plans that are current, the most recent parenting plan proposal is dated, what did I say, February or March? February. So if you're going to be requesting something different from the court, then go ahead and submit that recommendation to me. That helps speed up the hearing because I know what you're going to be asking me for.
Okay.
Okay.
Okay. I mean, so in those like proposed, can you have like stipulations, or I just was really hoping to talk today to figure out where we go from here. But
well, so I can't give you legal advice. What you would be submitting to me is what you want. And then she would submit to me what she wants. And then we would have argument on the areas that the two of you disagree. And I would be the deciding factor on those areas of disagreement.
Okay.
That help?
A recommendation?
Yeah.
Say that again.
So we just submit a recommendation?
Well, so because you don't have attorneys, you're essentially acting as your own attorney, and you need to submit me what you want me to sign. And then I review both of them and I say, oh, here's where I see agreement. Here's where I see disagreement. Why do we disagree? We talk about those areas of disagreement, and then I make a ruling on the areas of disagreement.
Okay.
Okay.
All right. Thank you.
All right. Thank you both. We'll see you on the 25th.
Okay.
Okay.
Still got her on there.
That'll be Cassandra Davenport, if you are with us.
Yes, I'm here.
And then Gregory Smith.
Reeves. Oops, sorry.
Reeves, sorry. My printed docket's all over the place today. Okay, Gregory Reeves, thank you. Cassandra Davenport. I had this on for temporary parenting plan review. Where are the parties
at? Do you want to go first, Greg?
Anyone's, feel free to jump in.
Okay, so I feel like a lot of stuff came up. I almost backed out, and I thought, the plan was that eventually we were going to get to a comfortable point where it would just be 50-50. And we both agreed on no child support. So I had submitted those. I had concerns about drinking and driving with my daughter in the car. And I just requested that if I have any concerns in the future, that I'm able to request a UA. But other than that, I'm okay with the 50-50. I did get served with her paperwork, and I'm not okay with that because I don't feel that that is 50-50. I like my time with my daughter, and like my schedule with my daughter is, I get off work, I go, through the whole routine. We hang out, feed her, eat dinner, I bathe her, I put her down for bed. I mean, I'm just doing this with my mom. Occasionally she sees her auntie, but I feel like we really have a good thing going on, and I don't want to have to go to her mom every night and drop her off at her mom's or have her mom pick her up. I kind of prefer to not have that much contact with her mom, and I just really feel good about what I have going on in my 50% of the time and don't want to give up any more than that.
I did just see, so when I actually reviewed this yesterday, I did not have your proposed parenting plan scanned into the file yet, Ms. Davenport, so I haven't had a chance to look at it. Looks like it was, you filed it on Monday, so it's available to me online today, but it wasn't yesterday when I reviewed this case in preparation. So I haven't been able to see where you all disagree specifically, but it sounds like we're not quite at agreed order place. So let me ask the two of you this. You've never had a guardian ad litem appointed. That is, you've probably seen them online where they interview both of you, other people involved in the child's life, and make recommendations to the court. Is that something that you would be interested in having involved in your case?
I would rather not if possible. So with me, I'm for 50-50 because I feel like that's the best thing for our child, to have equal time with her dad and me. It's very healthy for her and she's safe with both of us. My only concern is I was asking for first right of refusal because Adeline,
first right of refusal in this, what does it mean to you?
From my understanding, when it comes to custody, would be that he would call me if he needs childcare first. So instead of Adeline staying at her grandma's during Greg's days, he would still get his time with her, and then she would just be with me during the night instead of staying those nights at his mother's. And I want her to have a healthy relationship with his mom, which is her grandma. And I see how this is affecting my daughter and her relationship with his mother. She's really upset. She doesn't understand why, if she can't be with daddy, why she can't be with me. And it's really affecting her. And I feel she's 4 years old and I feel like she needs to be with her dad and me. And that's where she wants to be. So I don't understand.
So typically I rule that in these types of situations, absent extenuating circumstances, that the parent whose residential time it is gets to decide who is watching the child if they have to work or do other things. So I don't typically grant what you are calling first right of refusal is not something I typically grant. Here's my recommendation. You all appear to be close, but again, because your proposed plan was just filed, I haven't had a chance to sit down and fully compare them. I would recommend that we transfer this to mediation, have you all meet with a mediator to go through your differences and see if you can bring back an agreed plan to me rather than doing a GAL. Would you
How
guys?
much does mediation cost?
Let me pull it up. They just told me it's not much. Well, it's way cheaper than a GAL. I do know that. Okay. The charge per mediation, and it's done here locally, is $310. And I typically have the parties just split that 50-50. Would that be something that you all would be interested in?
If we have to, then yes. My other concern was basically the childcare that she is put with in Greg's time with our daughter. When she goes to her aunt's, she is exposed to so many foul things. She comes back with regression in behavior. She's very sexually curious. It's not healthy for her. They do drugs right in front of her.
And again, so we don't have, if there's allegations of drug usage, then I'm going to request a GAL. That's not something that I have documentation of. So if you're requesting that visitation be limited because of significant safety concerns to the child, then that is something we would need a GAL for.
That's not what I'm requesting. I don't understand why she can't be with me instead of going overnight to someone else's house when I could provide her stability. It's
not your parenting time. That's why.
Can I say something?
Yes, please do.
Yes, I wanted to ask your suggestion because I know that she has a thing against her sister. I have addressed all these problems. I have actually gotten mad at her sister and asked this stuff, and her sister gets very defensive, says she doesn't do that, that she's willing to take a drug test, hair follicle test. I don't know what to do in this situation because the last judge that we spoke to said, you know, Adeline was in her care for so long not to rip her away from her auntie. I have limited that she maybe once a week, if that, like sometimes she goes 3 weeks without even seeing her auntie. So it's like, mainly it's just me and my mom. And that is, you know, the best, you know, that's how I like it. But I do, you know, she misses her auntie. I sometimes, you know, let her go stay the night there. You know, I've addressed all these problems and, you know, I haven't taken it lightly. And she, within responses, says anytime, hair follicle test, you know, have somebody stop by, whatever. So I wonder if sometimes it's just something that's, you know, because they're sisters and they don't like each other. But I don't know what to do in this situation. Yeah, the easiest thing would just be like, yeah, she can't go there. But, you know, like she's going to miss her auntie and, you know, she was a big part of her life.
All right. So I think I've heard enough. I've looked at the history of your case. I am a little confused why we've never had a GAL appointed. I see that you guys, that this matter was in guardianship proceedings for a period of time. I, on the court's own motion, am going to appoint a GAL because there are a lot of allegations going back and forth. I don't believe this is something that you all are close in agreement on, even if it appears that way on paper. I think there's significant safety concerns that are being raised for the child. What is the current age of your child?
4.
Okay. Who are the next 3 GALs? I'm going to read off 3 names and then I'm going to see if you guys want to strike any of them, if you know them or had an experience with them. Ann Height, Twyla Corey, and Heather Cull. Do you want to strike any of those? Oh, I'm hearing no objection, so I'm going to sign Ann Height. I'm going to set some review dates in a minute, but first let's talk about payment. I'm going to ask you all a little bit about your income to determine if the county pays for this, you all pay for this, and at what portion. So Ms. Davenport, first, what is your monthly income?
Right now I'm currently temporarily on TANF. So I think it's 530.
Okay, so you're not currently working?
No, I'm taking classes to become a CNA.
Okay. And how much longer do you have in that program?
Probably about a month, maybe.
Okay. And then, sir, what is your monthly income?
I think roughly about $3,000.
Okay. And then is that before or after taxes? Is that your take home pay?
Yeah, I think that'd be about my take home pay.
How many people do you support on that?
3.
3 dependents?
Yeah.
Okay. So what I'm going to do is indicate that this will.
You have 3 kids?
Well, no, 2 dependents and 2 dependents.
But yeah, okay. So this is going to be county pay. What I'm going to do is indicate that 50% of it will be reimbursed by the respondent. And then 50% will be paid at county, or excuse me, at public expense. So that would mean the maximum the GAL can charge. Just going to get out my calculator here. In a county pay case is $1,485. So then the max that the respondent would be reimbursing at conclusion would be $742.50. The GAL is going to be, I'm also going to reserve on petitioner's reimbursement. We'll re-review if you do become gainfully employed before this is concluded. And then the GAL is going to be tasked with interviewing both of you about the concerns you have about either party regarding any issues of substance abuse, mental health, anything like that. We're going to do a 30-day review. So let's set that to, are the two of you free the day before Thanksgiving, November 22nd?
I think that should be fine.
Okay. So that'll be November 22nd at 9 a.m. Then the interim report will do. Let's do that the end of, now let's bump that into January. Let's say January 7, 2023, 9 a.m. Oops, did I get that date wrong? Hold on. January 10th, I meant. January 10th. And then February 14, hopefully for the final report.
February, what was that?
February 14. So the next hearing will be November 22, 2023. So when Ms. Height reaches out to the two of you, please make sure you get back in contact with her.
Okay.
Any questions for me in the meantime?
So the guardian ad litem will be getting hold of us first. We don't have to reach out to her first, or?
Correct. She'll be given your contact information and she'll reach out as soon as she has the document and the order in her file.
Okay. And what's her name again?
Ann Height.
Okay.
Okay. All right. Thank you both. We'll see you back November 22nd.
Thank you.
All right, thank you.
Okay, number 5 on my docket, Cassandra Davenport, Gregory Reeves, 233-0003408. We have Ms. Height on this matter. Let's see, do we have Mr. Reeves? Right. Okay, and who is Marlena that's turned on their camera?
I am Adeline's maternal aunt. Back in May of 2022, I started the emergency guardianship. And then May of this year, since Greg was doing everything he needed to do and was doing what he needed to do, I decided that to have her transition back to him. But I'm only here because Adeline, even before all this, since she was a month old, she's been staying with me weekly since she was a month old.
I'm gonna have you pause there for a minute. I'm gonna hear from the parties first, but I thank you for letting me know who you are and why you're here, and we'll come to you shortly, okay? Now, do we have Mr. Reeves present? Are you on the Samsung?
Yeah, he's trying to figure out his thing.
I just sent a request for you to unmute.
When court started, he was having some issues. It was showing just a screen that said the host will let you in soon.
Yeah, he probably was in the wrong courtroom. People log into the wrong docket that has not been started. Because if they log into this link, it puts them into our waiting room and notifies me. Okay, so Mr. Reeves, can you send a message and let us know if you're still trying to unmute? I've sent you request to unmute. Well, then so he's responding to me saying it keeps telling him the host is not letting you unmute. And I'm just telling you, I'm sending you requests as the host asking you to unmute. I haven't blocked your ability to unmute. So you'll need to log out and log back in. We'll come back to your case. I'm going to call one case in while we wait for him to get reconnected. And see if we have Mr. Reeves with us.
Yeah, can you hear me now?
Yes, we can.
Okay, perfect.
Thank you for trying that again. This is 233-000-3408. Let me just get back into that file. Just a minute. So when we were last here on October 25th together, we appointed Ms. Height. And I think this was just set on for kind of an initial review, essentially to make sure folks have been in contact with Ms. Height. So Ms. Height, let me just start with you. I know you were recently appointed, so I'm not expecting the world here, but just maybe a touch base on how things are getting started and if there's any guidance the court needs to be involved in.
Thank you, Your Honor. Started is probably too optimistic a word. I was appointed on the 1st. I sent out packets on the 2nd of November. And subsequent to that, I found out from Ms. Davenport that I had been given an incorrect address. I resent her packet on the 14th of this month. I have not received anything back, which is not surprising given that short time frame. Mr. Reeves' packet, which went out on the 1st, I've heard nothing back from. So I essentially have no information. My understanding from reading part of the file was that Mr. Reeves did not believe a GAL was necessary at this time. So I don't know if that's something that he was hoping to address today. That is literally the extent of my information today.
Okay. So I'm just looking to see, I think Mr. Reeves, since the last hearing, you had filed a request for reconsideration that kind of was in the form of a letter. So I'm not sure it really got logged in as such. So it sounds like you are stating you all have an agreement and you don't need a GAL. Is that what you are telling the court, sir? And then I'll come to you, Ms. Davenport.
Yeah, so basically I felt like there was just kind of some confusion. It might not have been listed under this case, but we had a GAL within less than a year. It was Mallory Smith, and I did submit the report. And I kind of just felt like this last case, we were ready to go to the 50-50, and then it came up about Marlena, her sister, and then that's when the whole GAL thing. I don't have problems with her sister and don't necessarily agree, but if it means the court can come to an end, then I have went into compliance with that. I mean, like I said, I don't think that Marlena is a bad person or anything, and I don't think it's bad there, but if it means court coming to an end because it's hurting my work, me financially, and all this stuff, I just want the 50-50. And then I kind of told Cassandra and her sister that they need to duke it out their problems. If there's like I know there's like grandfather or grandparents' rights. I don't know if there's like aunt rights or anything, but I don't feel like I should continue this court battle because of what they have against each other. I would just really like it to come to an end. I know that me and Cassandra have agreed on the 100%, maybe not necessarily the whole how she feels about her sister, but I really don't want to be a part of this and keep going to court. Like, my work's getting kind of upset with me. It's been going on for almost 2 years, and I just wanted to come to a close.
Ms. Davenport, what do you want the court to know?
Hi, that I am in compliance with the 50-50. I think Adeline is safe with Greg and I both. And there's no reason why she can't have equal time with both of her parents. And then with the whole Marlena thing, just a second. Sorry. I have to pause this. I'm sorry. My childcare went out of town for Thanksgiving. So.
Oh, totally understood.
Sorry. Yes, baby. Okay, I'll fix it. You're being very patient. Thank you. Which one? That one? Okay. I'm almost done, honey. Thank you. Okay, I'm so sorry. Anyway, I know that Marlena is attached to Adeline, but I do have concerns. Like the doing dabs in front of my daughter. When she was going around Marlena and staying the night, I don't believe my sister's done anything like that to my daughter. But
okay, so that's that's not what we're here for. So we're here for the first GAL review.
Oh yeah,
I'm hearing. Hold on, I'm hearing you and Mr. Reese telling me you don't want a GAL. I'm not reversing that decision. I am keeping Ms. Height on this case. I do feel like this court has to make a ruling on what's in the best interest of the child. And because I know that at some point a guardianship was filed for this child, I am not just going to take at face value from Ms. Davenport and Mr. Reeves what is in the best interest of the child. We do need someone else to meet with the parties, to investigate this, and to report back to the court. So that will include all parties involved. I am keeping Ms. Height on the case. We will, I think we set review dates otherwise. And what I would say is, Mr. Reeves and Ms. Davenport, please, you've received paperwork. You probably will also get requests to talk with Ms. Height. Those are court mandated obligations that you have. So I do need both of you to participate in that.
Okay.
I think our interim report review date is January 10th, 2024 at 9 a.m. So that will, oh, go ahead.
I'm sorry, Your Honor. I was wondering if the January 10th date could be moved to either the 3rd or the 17th of January.
Absolutely.
I am unavailable on the 10th. I'm available both of those other dates. And then the final review, as you see there, is for mid-February. I'm hoping that could still stand.
Okay.
The mid-February date. I don't necessarily want to change that one.
Okay. Let's do January 17. We'll strike January 10th and we'll change it to January 17th at 9 a.m. for the interim review. And then we'll keep the February date, but certainly we can revisit that on this January 17th if we need to, depending on how the investigation goes at that point.
What was the February date?
That.
Ms. Height, go ahead.
I just said thank you. I appreciate that change.
Okay, thank you. And then I think Mr. Reeves, you were asking a question. Go ahead.
Yeah. What was the February date again? It was like the 13th or the?
Yeah, February 14.
14th. And then I had so I have been waiting for a phone call. I didn't know it was going to come in the form of mail. I will recheck through my mail. Is it like a big packet or is it like just a regular letter?
It's a packet that looks like this.
Okay, I will re-look through my mail, and then if I cannot find it in there, then I will reach out to you.
Okay.
All right. Sorry about that.
Okay. Anything else we need to do today?
Can I speak now, or were you waiting?
So I don't know that I need your input today unless there was something real urgent and pressing. What?
Well, Adeline has been, even after my guardianship went to Greg, she's been staying with me one night a week. And Greg, which I can provide proof of this, but Greg and his mother both told me that Cassandra was harassing Greg really bad to the point because of Adeline staying the night with me. But she's been doing that since she was a month old. And her and I are extremely close. We have a very strong bond. And so now I am told that she can't stay one night. I was informed, this is how it was told to me, that if Adeline continues to stay one night a week with me, that they would reopen a case, and that Greg couldn't do that because of work and he just needed it to be closed, which confused me. And I was going to submit a statement, but I figured
Yeah. So ma'am, you're not a party to the family law matter. So if there's information that you have regarding what's in the best interest of the child, please reach out to Ms. Height. That will be the avenue for that. I can't actually take testimony from a non-party right now, just orally.
Okay.
So, because I understand I understand there's no guardianship in place right now today, correct?
Yeah. No.
Right.
Because Greg stepped up and did what he needed to do, me and the guardian ad litem at the time.
Understood. And that's why you wouldn't be a party to this family law case, even though you were a party to the guardianship case. That case has ended. But your input is valuable to Ms. Height. Please reach out to her. And then that information can come when we meet back on January 17th. But it is true, without a guardianship in place, you don't have legal standing over the child sitting here today. So you yourself can't mandate, visitation. If a parent chooses something different, that's certainly their prerogative at this time. My last notes show Ms. Davenport and Mr. Reeves stating that 50-50 was going well informally. And right now that's what's in place.
Yeah. And no, I'm not here for any visitation. I just wanted to kind of figure out what was actually going on in the case because.
Okay. And again, I'm going to go ahead and end the hearing on this matter again, because you're not a party. I can't give you legal advice. I mean, you're welcome to participate. I mean, you're not participate. You're welcome to watch these proceedings. But since you're not a party, there's really no kind of request you can make of the court in this case. But again, reach out to Ms. Height if you want to give some input.
Okay. Yeah. I have. Yeah. Okay.
Ms. Height, go ahead.
Thank you. Your Honor, my general system is that once I've received my intake packets and reviewed those, I set up visits with the child and the parents, and I do not typically contact collaterals until after that time. So it would be some time before I would have any information from Ms. Marlena. And with that in mind, I wonder if you could encourage the parties to return their packets as soon as possible. That would certainly help me move this forward.
Yes. I think that's completely realistic. And I think we did discuss that. Mr. Reeves and Ms. Davenport, go ahead and make sure you return those packets as soon as possible. I think we've done all we need to do today. I'm going to go ahead and end this hearing. Okay.
Thank you. Thank you, Your Honor.
Thank you.
Thank you.
Next, I have Cassandra Davenport and Gregory Reeves, cause 23-334-08. I'll ask if Cassandra Davenport's on the line.
Yes.
Okay, welcome to you, Ms. Davenport. And Mr. Gregory Reeves, are you on the line?
Yes.
Okay, welcome to you. All right, and also I believe Ms. Height is the guardian ad litem that's assigned to the case. We'll double check if Ms. Height is present.
Yes, I am Your Honor.
All right, welcome again. All right, so I've reviewed the guardian ad litem report, and I'll hear from Ms. Ms. Hyatt for some high points, and then we'll hear from Ms. Davenport and Mr. Reeves.
Okay. Thank you, Your Honor. I think the first thing I would like Your Honor to know is that through the course of this investigation, both parties have been very cooperative. They have very evidently had their daughter's best interests at the forefront. They've had a kind of a lumpy road along the way, and they've made some poor choices, but they both appear to be in good places right now. I visited with both of them in their homes, and Adeline was there for both of those visits, and she was very evidently comfortable, responsive, well cared for in both homes. So all of that together with the remaining concern, as you undoubtedly saw from my report, was that Mom is not committed to being completely alcohol abstinent, which is, it's okay, that's under control. And she, after some pretty frank discussion and some decisions on her part, she decided that she would be willing to do a breathalyzer type device for both she and Mr. Reeves to have. And that would be something that she would be amenable to in order to have the recommendations that I came up with. And those recommendations basically were based on what the parents felt would be in Addie's best interest and would be in good, it would work with both of their schedules well. So those are the responses, or the recommendations that I came up with. And again, I would like to say both parents are very committed to making sure going forward that Adeline has good, safe care and that they're both in a safe place.
Thank you, Ms. Haidt. One of your recommendations said that an immediate observed breathalyzer test. What is your understanding of the observed portion of that?
My expectation, I would just kind of trying to go through a scenario in my mind, and if there was some collateral report that Mom had been drinking and it was 4 hours till Adeline was supposed to come visit. And again, I don't have any reference of that except for my own imagination to try to figure out what would work. That is that there needs to be someone there that is agreeable to Dad, or Dad there to observe that test. For her to just click a picture of her device, I think it's not yet adequate. I think that there needs to be someone there who says, yes, she really did do the test and this really is the correct number. I believe that that's going to happen, and I'm optimistic about that at this point. But I think there just needs to be that extra of observation. And she was willing to have me come out and do that. She was willing also to have Dad come out and do that. And there may be someone else who they could both agree on. But I think that Dad needs to be in agreement that it's an adequate party.
Okay. Thank you, Ms. Heiss. All right, Ms. Davenport, could I hear from you as far as the guardian ad litem's recommendations? Any concerns with those?
No, I came up with the idea for the breathalyzer because I'd recently been in a car wreck, and I didn't flee the scene. The teenager that hit me, we both got out and decided that we didn't need an ambulance. I was turning into a driveway, and he came out of nowhere. He was speeding and driving like really fast and hit me, and he hit me so hard it pushed my car into like a pole and into like a cement barricade thing. Anyway, we agreed that we didn't need an ambulance and we didn't want to involve insurance. So that, I don't know, but I just thought that that's how it worked. I've never been in a wreck with someone else before like that. So he ended up leaving, and then I left, and Greg was concerned that I had been drinking. And I don't drink when my daughter is in my care. And when she isn't in my care, even then, I don't drink every day that she's not with me. And I was just trying to come up with ways to prove that if there ever is any concern or anything, that he can come to me or he can video call me and I will do a breathalyzer right in front of him, just to prove my innocence. But yeah, I don't drink around my daughter. And there was actually in this GL report on page 6, lines 16 through 18, the GAL said there remains the issue of alcohol use for both parties. And then on line 17 and 18, she says, the remaining concern for this GAL is the current alcohol use level of both parties. So I feel like I was just coming up with ways to reassure everybody. You know, I'm not doing that, but it's not just me that has had a drinking issue. And I'm feeling a little targeted, but my goal here is to have 50-50 joint physical custody, which Greg and I have agreed on prior. So I don't know.
Okay, thank you. And you're comfortable, Ms. Height made some other recommendations related to no romantic partners until 6 months of the relationship, introduction to the children, to the child. You're comfortable with that? Okay.
That's no problem.
And you're comfortable with no overnight guests during your residential time?
Yeah, my only thing is I was wondering if, does that mean, my friend Fabi, she has 2 kids that are my daughter's age, and sometimes we'll go over there and stay the night and hang out there, because of the fact that Greg and I only have 50-50, I only see my daughter 50% of the time. I don't really want to give up my time with her. I understand as she gets a little bit older, that's just going to happen. She's going to want to go to friends' houses. But right now, because she's only 4, I just find it necessary to be with her at a friend's house, I guess. Yeah, I'm okay with that as long as like she can have friends come over and stay the night. But
I think the recommendation is that there'd be no overnight guests when it's your residential time.
okay, does that mean she can't have her friends over, or is it just for me, like adults?
That sounds like an overnight guest to me, but I'll defer to Ms. Height.
Excuse me, I'm thinking of adult guests, that if they have an agreed on child to spend a night, a cousin, a playmate, that would be fine, but no adults along with that.
Okay, thanks for that clarification. With that clarification, Ms. Davenport, are you comfortable with that?
Yeah.
Okay. And then anything else, Ms. Davenport, before I hear from Mr. Reeves?
Yeah, just Greg and I agreed on joint physical custody, so 50-50, equal decision-making rights, equal time, because we feel like that's what's best for our daughter. She needs both of us, and we both love her and provide a safe environment for her. So
as far as the contours of that 50-50, is there an exchange date, or is it like on an exchange on a Friday, or is it a 3 days on, 4 days off?
we're going to do week on, week off, but we decided that's too long of an extended period for her to go without seeing both of us, especially at this young age. So we came up with the idea to do 4 days 1 week and 3 days the next. And that's what we've been doing for quite some time now, and it's working out. So 1 week we do Saturday at 6 p.m. I get her Saturday at 6 p.m. until Wednesday at 6 p.m. And then the following week is Sunday at 6 p.m. till Wednesday at 6 p.m.
Okay, and that mirrors what Ms. Height included in her report, it looks like.
Yeah, except for my other thing about that is on page, I'm so sorry, the page 8 for the recommendations. She stated that for Greg to be the primary parent and that we have shared decision making on education, medical, and extracurricular, and that I have visitations. But if we're doing 50-50 joint physical custody, I don't believe that there would be a primary parent.
Yeah, I think that generally, even though the time may be exactly 50-50, there's required to be a residential primary parent.
Okay, well, if there's a required, then I would like to be that parent because I do all of the things that a primary parent should do. So a primary parent is the one who performs the bulk of parenting duties for the child, correct? So I provide her stability when she's in my care. She's only with me. Her school district, she's in my school district. My work schedule doesn't interfere with her having to go stay at other places when she's in my care, like it does with her dad. And our relationship, my daughter and I are very close. I've been her primary parent since she was born. I'm her primary caretaker up until, all of this happened, till Greg and I made poor decisions. But I provide her stability and consistency. I got her signed up for counseling. I'm the one taking care of her doctor's appointments and dental appointments. And due to Greg's work schedule, it's a little complicated for him to do that. And she is actually only overnight at his house 6 days a month because of his work schedule. So I don't know. I feel like I should be the primary parent because of those reasons.
Thank you, Ms.
I can provide stability and consistency and just everything.
All right, thank you, Ms. Davenport. Mr. Reeves?
Yeah, I mean, I've had some hesitations on some things, and quite a few stuff has came up. I do feel better with this whole breathalyzer thing, and am willing to agree to the 50-50. I mean, I know that Adeline loves us both, and we both have good intentions for her. I'm okay with the 50-50 and us making decisions together and joint decisions. I would prefer to remain the primary parent. Like I said, some stuff has came up, and I am still, even with my work schedule, very involved. I've been to almost every single one of her counseling appointments before this. When she had the whole UTI thing, I went to X-ray. There was, all sorts of stuff. Yes, Cassandra is more able to make doctor's appointments and stuff, but I still feel that I can provide a more stable life. I've owned my house for 9 years. I've had my job for 5. If something happened, I could take her full time. And the people that I have her with is me and my mom mainly, and sometimes Marlena asks for her overnight, but I don't think that it's bad people that I have her with. I think it's a good environment. I have questioned Cassandra's environment at times, but I think that it's came a long way to agree to the 50-50, and I'm willing to do that, and I do feel much more comfortable, and I just want us to be able to move on with our lives. And me and Cassandra don't get along the best at times, but I think that slowly as it goes, I think we're gonna learn to co-parent a little bit better. But I think that she is still in good hands when she is with the other party. So I just hope that we can get this all settled and stop having to keep going back and forth to court.
Okay, thank you.
Can I say something?
So I think what I'll do here, it sounds like, I think the Ms. Hyde's comments at the beginning were very complimentary of both parents. So kudos to you for the way that you're handling things and caring for your child. I think that's really important. Sounds like she's in good hands. Sounds like the parties have had a rocky past, but it sounds like they're doing much better now. In particular, Mr. Reeves has indicated that he's completed, Ms. Hyde indicated that he completed substance use disorder treatment back in January 2023. And during that period of time, he had clean UAs. And Ms. Davenport, it sounds like her alcohol consumption is more in control, and she still continues to drink and expressed at least some hesitancy about undergoing SUD treatment based on time constraints and the like. And she's agreeable to do the breathalyzer testing observed between she and the father. So I think it all bodes very well for your child. So I appreciate your working together for the benefit of your girl. So the joint decision making, I think that's appropriate. I think notwithstanding differences, the parties get along well enough to do that. So that'll be ordered. And there will be no adult overnight guests during mom's residential time. And as we talked about, if it's a little friend, a small child, that's fine. Ms. Davenport is comfortable with no romantic partners being introduced to Addie until 6 months of the relationship in place. And that if that does occur, then Ms. Davenport would provide the to Mr. Reeves the name and date of birth of that individual. And so I think that it's a proper restriction that both parties not consume alcohol during their residential time with Addie. And the breathalyzer provision is also adopted in that Ms. Davenport will purchase 2 breathalyzers, give one to Mr. Reeves, and that he can request a breathalyzer reading 8 hours before and any time during Ms. Davenport's residential time. And it needs to be, he can request that, and it can be immediate, and it needs to be observed in whatever fashion he feels is appropriate, which could be, video conferencing, could be a party to be present, just needs to be observed by someone. I think the restrictions laid out by Ms. Hyde are reasonable if that there's alcohol detected in that breathalyzer test during those timeframes, and visitation to the mother is suspended for 30 days. And if there's 3 positive breathalyzer test results within 6 months, then the visits of Ms. Davenport just end at that time. They're suspended. They'd have to come back to court, and we'd have to take a fresh look at things. So I'll adopt that. As far as the 50-50 time, I think what's been laid out and expressed by the parties and Ms. Hyde is I'll adopt that. Week 1, mother's time will be Sunday to 6 p.m. till Wednesday at 6 p.m. Week 2, her time would be Saturday from 6 p.m. and Wednesday to 6 p.m. And of course, the father's time would be just picking up at where her time ends and his time begins. As far as the primary custodial parent, while it's simply a nomination of the primary parent, it does have some real legal effects in that if their primary parent makes a choice to relocate, they are given the presumption that the relocation will occur, and then the non-primary parent then works against that presumption. So it's not an insignificant thing. I think given what I've heard here today and what I've read, I will nominate the father as the primary custodial parent. I think in actual terms, it really doesn't have much of an impact, but like I said, there are some real-world legal impacts. So with that said, that's the court order, which mirrors pretty much what Ms. Hyde had recommended. I looked through the file, and you all not knowing what I was going to rule on, of course, didn't prepare a particular proposed order. So I'm wondering if one of the parties would be in a position to present or draft and send to the court a proposed order to review and sign off on.
Well, Greg, you're the primary parent now, so I think that's your duty because I'm the one that does all of this stuff.
So what do you mean by like a proposed order? Because I mean, I know I submitted in like the parenting plan like that we just discussed, and like do I just go in and modify any of the stuff that we talked about, or what do you mean by putting an order?
Yeah, it's a good question. I see that both parties submitted proposed parenting plans back in October. So I'm looking, pardon?
I submitted the first one actually.
Well, I'm looking at the most recent ones in October, so it looks like both parties submitted proposed orders then.
So I just have a question. Why am I being looked at for alcohol use when Greg, I have a letter from his ex-wife that she left him because he's an alcoholic and wouldn't stop drinking. That was the reasons for our relationship problems as well. I went through a lot of abuse with Greg because of it, and he still drinks.
So I'm addressing the issue of the proposed parenting plan. I'll get to your question in just a moment. I think it's probably just going to be easier if I just draft the order myself. So that's what I'll do.
And can I request?
Hold on. So I'll draft that and then I'll file it with the court. I'll probably have it done by tomorrow, possibly Friday at the latest. But I'll get that filed, and then you can take a copy of it. In response to Ms. Davenport's question, The reason I read the report from the guardian ad litem. She addressed alcohol as a concern for both parties. The one thing that I note is different between the parties. One party completed the alcohol substance use treatment and one did not. And
Okay.
we're done for today, and I'll get that order filed. Otherwise, I think we're just going to be rehashing things that I've already addressed.
Okay, so can we also add in there that I request random breathalyzers because my daughter now knows what beer is and says daddy drinks beer at home.
You're asking me to amend my order, and I'm not doing that at this time. If you have further concerns, you can file a motion to modify. That'll
Definitely.
be the matter for today. The next matter is Haley Brooks and Bradley Peak, house number 23-3.
It's been 11 months since that final hearing, and the only other entries in Odyssey are the order for a temporary parenting plan that Judge Evans said he was going to do up for them, and an order for compensation, making sure that Mrs. Height got paid. It's interesting to note that he did a temporary parenting plan and not the permanent one they had talked about doing. I'm not sure when they'll be back to court again, but I suspect it's only a matter of time if Mom doesn't get some treatment for her alcohol and anger issues. She obviously loves her daughter, so she needs to be healthy and stable for her. I also hope Dad continues to take his sobriety seriously. I think it's the best thing he can do for his little girl. He seems to be trying his hardest to be a good father and not disrespect his child's mother, but I think Mom may be struggling more with that. I wish them all the best. See you next time.